Well, good afternoon, everybody. Look at this. May goes, I just got the notification. I'm going between here and TC. Oh my gosh. Tony with the blue butterfly. Where have you been, girl? V's back. Look at that cane corso, Mom. To what do I owe the pleasure? Girlfriend, I have missed you. Poppy's back. Oh, yes. Mel's here. Jules is here. Woo! We have a lot going on. Well, there's a lot cooking in the courtroom today, too. Because, hang on. Hollywood 541 said, hello. Hero. Look at that. Kane miss me. Kane miss me. Look at that. Susan said, I miss your face. We all do. We all do. DT Driver says, I'm here again. Angel P said it's time. Now, I'm going to go ahead and tell you all something, and don't get mad at me. I took a little sneak peek at this, and it just kind of seems like she's going to get away with it. And we know who we're talking about. We're talking about Alexee Trevizo. The girl that no one knew was pregnant. The girl that didn't know what to do when she had a baby in the bathroom. Yeah. Let's go back to the original autopsy. The autopsy revealed that the newborn did not have any physical abnormalities or injuries at birth. It was observed that the air was present in the lungs and stomach, suggesting that the baby was likely born alive after a full 38 weeks of pregnancy. The autopsy, medical science, indicated that the baby might have been suffocated. Well, today, they are arguing stillbirth. Tana's here. Hollywood said, give me a break. Her mother must be blind and dumb. Well, let's take a second and welcome everyone back. All right, we are back. So I'm going to give everybody a little bit of what I call a refresher course. Okay. This is what happened when Alexee was in the hospital with back pain. And we know hospitals are busy. We know it takes a while for them to get test results back and everything. Listen, they had 9 months of test results. They had 9 months of test results. Exactly, Kat. Replay Brooks, the replay queen. Brooks loves to look back in history. Now listen, this is not a case where people say you can drop the baby at the Quick Trip or at the fire station. A hospital for a newborn baby is as safe as it gets. This is what Alexee did.
Oh my gosh. I'm sorry. It came out in me. I didn't know. Alexee, I told you about this. I just asked you, baby, to tell me the truth. I was scared. It was not crying or making.
A 19-year-old woman who allegedly killed her newborn son by stuffing him in a hospital trash can is released from jail on $100,000 bond ahead of her high school graduation.
Like, how big is the baby?
It's full term.
What? 9 months? Nothing was crying.
Officials say Alexee Trevizo went to an
Nothing was crying. Nothing was crying. But the whole family's there for back pain. Get out of here with that noise.
Artesia, New Mexico hospital in late December complaining of severe back pain. Disturbing body camera footage from January 27th shows hospital staff speaking with officers after a newborn was found inside the bloody bathroom Trevizo had just used.
The baby's dead. Okay, we have him in trauma too, but she killed the kid.
The newborn baby died, and Trevizo was charged.
He said right there, she killed the kid. She said nothing was crying. Nothing was crying. Since when is a baby a nothing? I get so sick of these damn people thinking that a baby, a child, newborn to whatever age is a nothing.
Charged with first-degree murder and tampering with evidence. But just this week, Trevizo was released from custody on $100,000 bond. Court documents show Trevizo will be allowed to attend her high school graduation on May 25th. She'll be required to follow a 7 a.m. to 7 p.m. curfew, but will not have to wear an ankle monitor or be placed on house arrest. She'll also be allowed to leave the state of New Mexico and visit family in Texas unsupervised. Defense attorney Charles Ritgers tells Law and Crime Network those stipulations are not unusual.
I don't think that there's anything surprising or unusual about it. Number one, she should be considered innocent until proven guilty. One. Number two.
Who the fuck is he? Alexander Hamilton? We get it. We get it. We don't just put people in jail, throw away the key, and take away all their rights. It's called a charge. It's called an affidavit. It's called a probable cause. I get so sick of that shit. When people come in, they're like, innocent till proven guilty, innocent till proven guilty. Look, I'm not Kendall Ray. I don't talk about cases that were solved 5 years ago. Fun fact, I wish I was Kendall Ray, because that girl got it going on.
More importantly, as far as deciding whether to give her a lower bond or what have you, she's not a flight risk. She's a 19-year-old girl. Unless she's an heiress to some fortune where she can flee the country or whatever, but I'm sure that the court, if that were the case, would have probably confiscated any kind of passport, which is standard. So I don't think she's a flight risk. The whole purpose of bond is to make sure that someone shows up in court. And probably $100,000 in this situation is more than adequate to make sure that she shows up.
Ritgers may be most known for representing Brooke Schuyler Richardson, the Ohio woman accused of murdering her newborn.
And that bitch is married to a guy named Max Grammer. That bitch is married. It's another one of those, oh, Nothing was happening. It looked dead to me. Bitch, you knew you weren't dying. You felt the pain. It's almost impossible to give birth to a stillborn baby without assistance. Almost impossible. Look at that. Mandy for Bama is a new YouTube member. Seems like she really likes football. Mandy, I gotta tell you a secret. Everyone plug your ears. I'm an OU fan. Boomer Sooner. Norman, Oklahoma. Look, as she said, I became a member. I absolutely love it here. Jenbug likes it here too. I'm waiting on Jenbug to get my Halloween cactus ready. We have great friends here. You found a great place to land.
Born baby and burying her in her parents' backyard when she was 17. At trial in 2019, Richardson was found not guilty on all charges except abusing a corpse.
And I just wanted to say how sorry I was. I can sometimes be selfish, but I would like to think that I've become better in the knowledge that I've upset everyone and hurt so many people with what I've done. And I'm forever sorry, and I'm so sorry. I'm really, really sorry.
She's still scarred by the whole thing. There's no question about it. And for the longest time while the case was pending, she was locked up. And, you know, everybody's thinking the worst of her. And it took a while, I think, for her to really trust us. And she opened up, and it was great. And it was like, it was good for her to open up and know that we were 100% behind her. There was a plea bargain offered, and she was very brave in turning it down and said, I did not kill my baby. And she did. There's no question about that.
In Richardson's case, Ritgers says expert witnesses for the defense helped secure her near complete acquittal. That, along with an inaccurate narrative that she burned her baby's corpse, he says, was perpetuated by.
Okay, JD said there's another one in Kentucky I'm sure everybody has heard about, Lake and Snelling. We did a show about it. What was it? Monday afternoon or Tuesday afternoon? Yeah, if somebody wants to put it in here, yeah, go back and check it out. Go check it out. I'm so sorry. I'm so sorry. Nothing was moving. Nothing was crying. Fucking Colonel Sanders. Look at him.
Still as tasty and delicious as it ever was. I'm Colonel Sanders. And I'm back, America. I'm back, America. It's still finger-licking good.
Mm-hmm. She should have had her boyfriend lick her fingers instead of what they were doing, the horizontal boogaloo and blaming her pregnancy belly on McDonald's Big Macs.
She found air in the baby's lungs, which they claim would indicate a live birth. It's going to depend a lot on that finding, number one.
Ritgers says Trevizo's attorney should be prepared to find experts of their own.
If they're experienced trial lawyers, they probably already know that a lot of this is going to boil down to the actual path report, the autopsy, and they'll need an expert on their own to determine whether or not there really was air in the lungs, whether that really means that the baby was born alive. We don't know whether there was any other signs of trauma to the baby. So I don't know if our case would be that helpful, other than they do need some experts.
If Ritgers were to represent Trevizo, he tells us he would begin with gathering background information.
I would want to know all the background on the
I've got your background information. It's called Mr. Boyfriend borrowed his mom's minivan and they did the horizontal boogaloo in the back. That is the background information. That's all you need to know. Okay? That's all you need to know. There is no background information. I mean, if you're talking medical, hey, have all at it. Have all at it. You have all the medical information. That is the background. That's her and Mr. Boyfriend who refused to give his DNA to the courts. And look at this. Janie has just become a new YouTube member. I tell you what, I'm going to celebrate all of you right now. Okay, so what we're getting to right now is the oral argument to the Supreme Court of New Mexico, not of the United States. Oral is something maybe Alexee, Chicky Boo in Kentucky, and a few others should have tried if you're that horny. I promise, there's more than one way to get off. Okay? Look at my husband. Look at him. Janie, you're going to like it here. You're just really trying to be a moderator, aren't you? May said Farmer's Almanac is out for 2026. Shit show predicted. All right. Now I'm going to mute myself so we can hear it. I'm not liking any of the conversation.
Good morning. We're on the record of S1SC 40487, interlocutory appeal, State versus Trevizo. We have on opening 20 minutes. You may enter your appearance and proceed.
Thank you, Your Honor. Michael Thomas, NMDOJ, Raul Torres, Attorney General for the state.
Morning. You may proceed.
Thank you. May it please the court, counsel, and attendees. This case, still at the pretrial stage, involves two narrow legal issues, specifically whether the district court's decision to suppress evidence was factually supported and legally sound. The district court erroneously concluded that there were violations of Miranda and of the physician-patient privilege. Many of the court's key findings are either not supported by substantial evidence or, even if they are, do not support any assertedly related legal conclusion, revealing that the district court was mistaken about the applicable law. The interaction of the doctor, other medical staff, and defendant, as well as the police, are captured on the lapel video in the record as Defense Exhibit H from the suppression hearing. A careful review of the video is critical to a proper understanding of the issues, as it undercuts a myriad of defense assertions and glaringly fails to support and outright contradicts the district court's findings, as well as various characterizations in the ruling.
Counsel, I'm going to interrupt you in two things. First, you need to slow way down.
Oh, he. Oh my gosh. He. Everyone, let's be nice in chat. Okay. I know Chrissy's not a nice person. So if Chrissy has something to say, well, Chrissy's actually an amazing person. But the whole I need you to tone it down. Tone it down. I need you to. There's nothing funny about a dead child.
Second, I'd like you to address pretty much right out of the gate State versus Ibarra.
State versus
Ibarra. It seems to be a case that answers this question a little bit.
And I'm not immediately familiar with that
Okay.
case, Your Honor. I'm sorry. I'll try to do my best to answer your question.
Okay, so I'll try and tee it up a little bit for you because I don't want to completely catch you off guard. So this is a 1990 Supreme Court case. And in that case, it's discussing the term interrogation for purposes of Miranda, which seems to be an issue here. And it says that under Miranda, Miranda refers not only to express questioning, but also to any words or actions on the part of the police, other than those normally attendant to arrest and custody, that the police should know are reasonably likely to elicit incriminating response from the suspect. So that's that concept. Does that help?
Yes, and,
Okay,
Your Honor,
good,
and I do remember Ibarra. Sorry, I
Okay,
didn't
no,
understand, but then I recognized it was Ibarra, which is cited in the brief. So
Yes, okay, no, that's okay. So I would like you to address that statement that comes from Rhode Island versus Innis, but was adopted by the New Mexico Supreme Court.
Yes, thank you. And I do recall Ibarra in the briefs. Your Honor is right that interrogation under Innis can be express questioning, or it can be, as Rhode Island Innis talks about, actions or statements by the police that are, as they say, that the police knew were reasonably likely to elicit an incriminating response. The reason why the state believes there's no interrogation here, Your Honor, is when you look at the video, just so we're all starting from a baseline, the police do not ask her any questions at all. The police do at one point ask the mother, did she have a driver's license? They hand that over. Of course, they're going to run everyone for warrants, like showing up at a car accident scene. But as I cited in the briefs, you know, we all are familiar with cases that say they're asking for a driver's license thing, and that's procedural. That doesn't count as interrogation. So then the question would be,
Okay, he is talking way too fast. It appears to me that he's never faced a panel of judges like this. And he needs to tone it down. We'll get through it. All I'm doing is reading and interjecting.
the police say anything that would be, as Innis says, reasonably likely to elicit.
Was not saying it can be actions as well. And that's what I want to focus on is actions. Because I get that the police didn't say anything, they didn't ask questions. But here my concern is that if we only review the video and that's out of context to what the police have been told prior to going into the room. There's been a report. They've heard from the nurse, probably things maybe the nurse shouldn't have told them. And then they're invited to go in. And so there's action as a result of that that's different than like they just pop their head in, or if the report had just been made without healthcare folks tying the report to this young lady. That might be different if they were just going room to room saying we'd like everybody's name and information. But here they had this body of knowledge before they walk in the room, and that's what troubles me in this case.
Yes, and I'll do my best to answer it. And of course, I know we'll get to the agency issue later, that the other side is arguing that the doctor was an agent. But yes, just strictly actions of the police. And I do appreciate the court's questions in focusing this. We know that it's an objective test for custody, but but now we're talking about actions that can be arguably that would have caused or been the equivalent of interrogation under Innis. The state doesn't believe the police did anything here. I'm glad that the Justice Bacon brought up the question of, well, that the nurse went up and talked to the doctors. The charge nurse went up and talked to the police when they arrived at the hospital. I don't see a problem with that because, I mean, generally when the police arrive at a scene, they're going to want to talk to the reporting party. Now, granted, the doctor, whoever it was that called the police, the reporting party here is a little ambiguous. It's essentially the medical staff of the hospital. It's not like a neighbor calling the police on a loud party next door, but the police naturally are going to want to talk to the doctor, the nurse, get a little bit of information before they barge in there. I think the police acted very reasonably here. They talked to the doctor, they talked to the nurse. And I think the police are smart enough to realize that just because this charge nurse is telling them this, that, and the other, that's just for the police officer's information. The defendant didn't even know what was being told to the police. So my point being that nothing that was said to the police in the hallway would have even been known to the defendant. So going back to the
Counsel,
justice.
that's always the
Counsel, my concern here is, and I'm curious, why did the police feel like they needed to go in the room with the doctor while she's talked about the defendant's treatment? Because the doctor told the police before she went in the room, I need to go tell her about what her condition is and what we need to do next. And then she says, will you come with me? Which I find a little strange, but why did they feel like it was appropriate for them to go in the room with the doctor to discuss treatment?
Well, I would say that at that point, they clearly had reasonable suspicion, probably more than that, given that the medical staff was, and I'm doing my best to answer your question, the medical staff clearly knew that the only person that had been in the bathroom during that entire relevant time was the defendant. This was not going to be a whodunit. So you're right.
Okay, take a breath, dude. Take a breath. We know it's not a whodunit. She was the one that gave birth in the bathroom. She is the one that acted like nothing happened, even though she saw an entire baby boy come out of her. And she got back in the bed like nothing happened. The police were investigating a possible murder. The autopsy shows that her child, her son, was born alive. I'm not quite understanding how things go in New Mexico and why we're having oral arguments with the Supreme Court of New Mexico. Don't get it twisted. It's not the Supreme Court of the United States. I don't quite understand where this money is coming from. I don't understand why anyone is trying to protect her and not protect the child that was clearly suffocated. And that's according to a medical examiner.
The doctor does say to the police officers, look, I need to tell her what's going on. I got her accepted to Loveless in Roswell. I need to tell her what's going on. She's bleeding. I need to make sure she's stable. The doctor simply says, does one of you want to go in there with me?
No, that's not what he said. She says, I need to make sure the mother is stable. I don't know if she delivered a placenta. She's bleeding a lot. And she immediately asked the officer, quote, if one of them is willing to be part of the conversation, and invited the officers into the hospital room, and they both agreed. So that's, I want to be clear on what the facts are. And she says, I want you to be part of the conversation, and they both agreed. Secondly, and maybe this is another way of asking the question that Justice Vargas asked, is there any medical reason for the officers being in the room when she's confronted? Is there any medical reason for inviting the officers into the room?
I would say I don't know that there was a medical reason for them to be in the room, but
is there any police reason? Is she a threat? Is she getting up and running away? Is she doing any of those things? Is there a suspicion she has a weapon? Or is there any police reason for them being in the room?
And to try to answer your question, Justice Beal, I appreciate it. I've watched the video about 10 times. My memory of the video is I don't remember the doctor saying, do you want to be a part of the conversation? I remember her saying something like, does one of you want to go in there with me?
But assume for purposes of this that that's what happened.
The answer, I do believe they had a legal reason to be in there. They were conducting an investigation.
Investigation of her medical condition?
Well, investigation of what led to the baby being put in the trash.
No, she says.
But if they're investigating,
she says.
got Miranda.
Well, Miranda requires custody and interrogation, which I'll get to in a minute. But my point is that there's no legal bar to the police going in the exam room. Now, granted, I admit it. As the doctor said, look, I need to talk to her. I don't want you in there yet. Can you hold on while I talk to her? I think the police, you can tell from the video, they were very deferential to the doctor. One thing I wanted to point out, because I believe now is a really good time to say that, there's a lot in the answer brief that suggests that the police presence there caused a delay or hindered treatment of some kind, or even delayed possibly her being flown to Roswell. I want to be very clear. There is absolutely zero evidence in the record that would support any fact finder in finding that any medical procedure or care was.
This is a hospital staff that's waiting on test results, waiting on the doctor to make doctor rounds, do doctor things. A girl says, I have to go to the bathroom. She's caught on camera, running down the hall holding her ass. She delivers her baby by herself with doctors and nurses right outside that bathroom door. Do you think when the housekeeper found a dead baby in the trash, they might not have been just a tad bit freaked out? That's not an everyday occurrence at the hospital.
Hindered or delayed, or that they even had anything to do with the helicopter arriving. So what I would say is, the best answer I have is I don't believe there was a medical reason for the police to be in there, but clearly the doctor did not say, I want to talk to her in private. I don't want you in there yet. I know we called the police, we called you, but please don't go in there yet. I need to talk to her. Do they have a legal reason to be in there? Yes. Now, might it have been
What's the legal reason?
Well, they're investigating this, and they probably want to, at some point.
Watching her get a pelvic exam, is that investigation?
Well, later on in the video, there is a point in the video when the nurse says, will you two please step out? And the police do. They step out of the hallway because there was probably a medical.
Was that hindering their investigation? Asking them to leave?
No, it wasn't hindering at all. And the police were very polite. They went out in the hallway. Another thing I wanted to mention too, and again, I think some of this is more clear when you sort of watch the video from beginning to end. There's a point in the video, pretty much exactly at 3 o'clock, where you see the police are out in the hallway. And they say to the nurse, they say, well, we don't really want to go in there and cause her more stress. She's dealing with a lot. And at that point, at 3 o'clock, you see the sergeant and the other officer go back into the room when they've clearly been out in the hallway. And the sergeant says, look, we're going to continue waiting out in the hallway. We don't want to add to your stress. We know this is stressful. And then the sergeant even explains, we can't have your mom in here right now. We're waiting for the detective. You are 19 years old, but we're going to keep waiting in the hallway. We don't want to add to your stress. I know at answer brief page 9, it certainly seemed to be making the claim that the police were in their room the entire time for that 2 hours or 2.5 hours, and that's just not true. From 3 o'clock until she was taken away by the helicopter at 4:30, pretty much 99% of that time from 3 a.m. to 4:30, they were waiting out in the hallway. And I don't know if I answered your question, but
but that was after the incriminating statements were made that were suppressed.
Well, yes, but the one thing I hadn't gotten a chance to get to yet was that it's 3 minutes. It's 3 minutes into the lapel video that they tell her, you're detained. You're not under arrest, but you are being detained. Put aside, of course, the cases that talk about being detained is different than being in custody for Miranda. Even if this court believed that she was in custody at that point, 3 minutes into the lapel video, and everything else was suppressed, she had already made the statements, and that's why I mentioned in the brief in chief that the motion was a little bit broad, and not the other side's motion was a little broad in not limiting the request to exclude statements to at least the point where she was told, you're not under arrest, but you are detained and you're not free to leave. But it was a little bit overbroad. And the case here, I'm trying to find the case really quick. Yes, State v. Philemon v. 2018 NMSC 11 talks about the difference between investigative detention and a custodial one, is that the latter, meaning custody, involves coercive conditions as to constitute the functional equivalent of an arrest. The one thing I also wanted to notice, and I know I'm not trying to get away from the interrogation, I'll be glad to answer any other questions on that. But of course, we know that there has to be both interrogation and custody. Putting aside the agency issue, Santiago case, whether the doctor acted as an agent of the police, there's clearly no custody here. And the cases that support that are 3 cases, both one in New Mexico and 2 others. State v. La Couture, 2009, NMCA 71. And that's the case that was provided in the Notice of Supplemental Authority back in March. And La Couture, some of the things they say in that case are almost 100% applicable here. What La Couture said was, La Couture, and this was, he had been involved in like a DUI or some kind of accident. He was in the hospital for injuries. And what the court said was, the fact that La Couture, this is paragraph 18 of La Couture. The fact that La Couture was restrained by injuries and medical accoutrements warrants little consideration. This is a Judge Kennedy Court of Appeals opinion. La Couture was exposed only to circumstantial restraints, and as stated above, the record indicates no action by Officer Diaz to restrain him. And La Couture, just to be clear, is not an outlier whatsoever. In the reply brief, I cited State v. Garrison, a July 2024 Connecticut Supreme Court case. And
so is it your argument today that the custody was circumstantial custody? Because it's not like, I mean, she's just delivered a baby, is bleeding out. It's not as though she's going to flee at that point. So are you asserting that there was no custody at all, or is it circumstantial custody from your perspective?
Well, custody, of course, can be formal arrest, or as the cases talk about, a restraint on liberty that basically, what's this, how they phrase it? Yes, when the person's freedom of movement has been restrained to a degree associated with a formal arrest.
So that was a follow-up question just Bacon I had, which is, so is the restraint of movement of the defendant based on the condition or that there were officers in the room? Does it matter?
Yes, I don't believe it does matter, because on Garrison and there's also this Johnson case that I cited in the Notice of Supplemental Authority 2 weeks ago, talk about the fact that if you're in a hospital, yes, officers may be present, but if the officers are not doing anything additional.
This guy is making me anxious. Big time anxious. I get that he's pleading to the judges. I imagine it would make your butthole pucker to see one judge. But he's the Attorney General confronting all these judges. He really needs to slow down.
To limit your freedom of movement, and they're being polite, they're not being antagonistic. That alone is not enough for custody. And in Garrison, it talks about an example in Garrison at page 289. It's 323 8th 289. The court says, because there is nothing in the record to suggest that any of the officers with whom the defendant interacted were threatening or aggressive, we conclude that the tone and tenor of the questioning weigh against the conclusion that the defendant was restrained. And I can't find it off the top of my head. The court talks in there about the fact that the real key is whether the police did anything to further restrain the movement. And probably the case that really best addresses that is the Johnson v. Commonwealth of Virginia. This is, again, 2 weeks ago, Notice of Supplemental Authority, 916 Southeast 2nd, 910. And what the court says in that case at page 921, so this is 916 Southeast 2nd at 921, the court says, the medical equipment connected to Johnson would have made it difficult for him to get out of bed, but his immobility was not caused by the police. Johnson was receiving essential medical care because he had shot himself in the chest.
I follow all of that, but here the police didn't leave. They stood outside the door. They said, we're standing outside the door. They shut the door. Isn't that some evidence of restraint or custody where they didn't have to, handcuff her because she's medically unstable? But isn't the fact of their presence and standing outside the door to prevent somebody from coming and going, and they're monitoring exactly where she's going, they know she's going to be transported, all of that, isn't that some indicia of further restraint based on the language you just read to me?
I don't believe that would meet the test of State v. Munoz cited in the brief, which is the degree associated with a formal arrest. Because again, when you look at La Couture, Johnson, and Garrison, they really are saying that if yes, you may have an IV line, maybe you're injured, you may not practically be able to leave the hospital, but the police aren't doing anything to further restrain you. So I don't believe them waiting out in the hallway would be custody, but certainly any such finding would have to be limited at least to the point about 3 minutes into the appel video when they say you are being detained, you're not under arrest, but you're detained, you're not free to leave. But unfortunately, the trial court's ruling suppressed even the statements you made earlier when the police literally were just standing there not saying a word and the doctor was talking. I know that gets into the agency issues.
Well, it also gets into the privilege issue, and your time is limited here. Setting aside Fourth Amendment for purposes of our conversation and the privilege, it appears that the state is taking a position that everything that the victim said is admissible because of the doctor's requirement under statute to report that as a crime. And I'm struggling with that. I can see the doctor, as she did, say we have a deceased individual and I need to report that. But the rest of it seems at that point, you're just opening it up and all the privileges are just waived and whatever that defendant talked about is admissible. Can you address the privilege issue?
Yes, I'll do it very quickly and I'll be glad to do it more on rebuttal. Two things, 11504D4 does have the exception, and as I noted in the brief, this court clearly has, as the issuer of that rule has, and I mentioned this in the brief, has a common law ability to interpret that rule. I would say 11504D4 certainly covers this, but the other big issue is the waiver. The fact that she spoke to the doctor with the police present and her mom present.
Okay, so mom's there to take care of her.
Well, she was 19 years old though.
Okay. And the officers, to Justice Bacon's question, and you can address this, I'll give you some time. They were at least guarding, at least if we're not going into the Fourth Amendment, they were in there. So that's a struggle with that waiver.
And she's on a myriad of drugs.
And I understand so real quick, the only thing I would say, Your Honor, if you allow me 10 seconds, is that
it's okay.
Imagine if the situation had been the doctor had gone in before the police got there. Let's say the police were on their way and the doctor goes in and says, well, I'm sorry to tell you, but we discovered a dead baby in the bathroom. And then she says, I'm sorry, it came out of me. I didn't know what to do. I think that would not have been privileged. And let's say the police arrive 3 minutes later, because that goes to the heart of the 11504D4 exception. So I think one way to look at it is, had she made that statement in response to the doctor's statement, we found a dead baby in the bathroom, even had the police not been there, I believe that would have not been privileged under the spirit of State v. Strouch and 11504D4. And I'll sit down and wait.
No, don't.
Take your time.
Justice Moore has a question. Justice Moore, did you?
I was more clarifying that you talked about the mom being present during the conversation and the statements made by defendant. And yes, the defendant was 19, but I might be remembering wrong. It's entirely possible. I want to see if I am. Wasn't there something she signed authorizing her mom as a caretaker or a party that she wanted? Maybe something where she wanted her to be present during the medical treatment. And does that do anything with the waiver issue? If my question makes sense.
I don't know if I can answer that off the top of my head without going back and looking at the record, but I believe that the general rule is that the presence of a third party is not strictly necessary, like a paralegal being there during an attorney-client conversation causes it to be waived. Thank you for the answer.
Thank you, Mr. All right. 30 minutes for appellee. May enter your parents and proceed.
Thank you, Chief Justice. My name is Amber Feyerberg on behalf of the defendant. Good morning, Chief Justice, justices of the court, counsel. As I said, my name is Amber Feyerberg. I represent Alexee Trevizo, the defendant appellee. The legal issues here, although that conversation got somewhat convoluted, are actually relatively straightforward. It's the ramifications of this case that are extraordinary for Ms. Trevizo and for every vulnerable patient in New Mexico, and for the state's commitment to safe, confidential reproductive health care. And even more importantly, to maintaining the line that separates medical care from police investigations. Physicians and medical personnel take on the role of caregiver. Police take on the role of investigator. If we accept the state's position in this case, that line completely disappears. And it's to the detriment of New Mexico patients at their most vulnerable moment. Police are in the emergency department every single day. This is something real live doctors have to navigate every single day. And the people who are there are inherently at their most vulnerable moment. There are guidelines here. The state's position is essentially there is no limit. If there is a reason to report, and I want to get into later which reporting statute is actually applicable here. I would argue it's a suspicious death and not child abuse. Those are two separate reporting statutes. But the state is arguing if there's a duty to report, there is no privilege, there is no Miranda rights, there are no more rights. We just go on in this joint investigation.
I'm not sure that I agree that that's where the state's gone. You're blending the two. I think Miranda, the argument as I understand it from the state, isn't related to the duty to report. I think
Idiots. She wasn't under arrest at the time. She freely spoke. The duty to report. People love throwing that word around. Mandated reporter, mandated reporter. When you work in a hospital, or you're a firefighter, you're any sort of first responder, when there is a dead infant, you have what's called a duty to report. Mandated just means see something, say something. That's it. That's crazy. That's crazy. And this whole HIPAA angle, well, nothing's going away. We all heard what she said. We're talking about a dead baby.
I think the duty report becomes important in the privilege conversation that I really do want to explore with you today. But Miranda just seems to be, they were invited into the room and they didn't do anything. They were polite, they were nice. I heard that a lot. And therefore there was no detention, no interrogation.
Yeah, thank you for the question, Justice Bacon. And you're right. You're absolutely right. There is the mandatory reporting falls under the privilege issue, where I think the state is largely mistaken. But let's talk about Miranda for a minute. Let's talk about that custody, because all of the cases that we just heard counsel cite are completely distinguishable here.
So when the state agrees that there was no medical reason for having the police officers in the room, does that bear on Miranda?
Absolutely.
Tell me how.
Absolutely. Well, to answer your question, Justice V. Hill, there are basically two universes we can be in. We can be in an investigatory universe where Miranda applies, or we can be in, we're here to support the doctor, and we're in the medical universe and privilege applies. The state can't thread the needle through those two by admitting that there is no medical purpose for the police to be in the room. That's effectively an admission that they're there to investigate a potential crime.
But is investigation the same as interrogation and detention?
That question doesn't go to custody. I am interested in that. I mean, does the answer, Senior Justice's question, mean they're in custody? Because then you get to interrogation.
Well, I want to make sure I understand your questions. So I want to make sure I understand your questions appropriately before I answer. There is a difference between investigation and custody, but in this case, there wasn't. In this case, there wasn't, and the reason is because of that pre-confrontation conversation that occurred in the hallway that the justices were discussing earlier, and that's that conversation where police are told by the charge nurse that she entered the bathroom to, and again, the charge nurse never treated Alexee.
That really seems related to interrogation. We're talking about custody. The question is, was she restrained? Was she free to leave? Those are the kinds of things we're looking at when we're deciding whether she's in custody. And what I'd really like to hear your take on the two cases where custody is an issue in New Mexico, and we're dealing with medical care emergency rooms, and that's Ibarra and La Couture. Ibarra, we have a defendant who is clearly in custody, He's been arrested already and he's taken for medical treatment in the emergency room. And then we have La Couture where they're not in custody yet. Tell me how those cases bear on this situation.
Absolutely. Ibarra says, and I don't have the pin site on me, but Ibarra says, I do have it. Ibarra uses the term an inherently coercive environment to describe the emergency department. And that's directly contrary to what the Court of Appeals said in La Couture, which effectively said this is just a normal situation, but that was factually distinguishable.
But Ibarra was already in custody. There was
Correct.
no question about custody in Ibarra.
Correct. Your Honor is absolutely right. The reason it matters, though, is because that inherent coercion also goes to custody under Munoz. Munoz gives us, the conversation earlier with counsel got really focused on custody only being a restriction of freedom to the degree normally associated with formal arrests. But in New Mexico, it's disjunctive. We have two ways that somebody can be in custody. There's that way, which normally comes with handcuffs and everything else. And then there's the second, which is that a reasonable person in the same situation, and in this moment, let's put ourselves in the mind of a reasonable 19-year-old high schooler, would not feel free to leave. And that's where Ibarra, I think, is so important, Your Honor, because it talks about the inherently coercive environment of the emergency department and cautioned police against exploiting it.
I ask you just in answer.
Hold on. Coercion of the emergency department. They're there to help people, not tell them what to say. This is ridiculous.
Patient privilege in the context of everything that's going on. She never had a chance to waive.
Correct. Right.
There's no waiver.
Right. You can't waive a right that you've not been informed about.
And she had no, and by the way, a fact I think that you left out, and I don't think you meant to, the custody, is that the officers were armed.
Absolutely.
Visibly armed.
Absolutely, visibly armed. And if I could just add one more thing to speak to that, Justice Vigil, and also finish answering your question, Justice Bacon.
The police are visibly armed? I would hope so. Would anyone that needs help, do you call the police or your local Boy Scout troop? What do you want? A slingshot and a harmonica, or someone armed to the gills? These are judges, my friends. These are judges. And let's not forget that the people that were in the ER that night were petrified, mortified, horrified, trying to help a patient. Boy, this is a little too much for old Brooks today.
Also fit into other persons, because the reason is because of what the doctor said. That and the charge nurse verified it and said the exact same thing. No one's talking to Alexee, aka no one's treating her except in the presence of police. So in that situation, they're absolutely in furtherance of care because she's not.
But how is the mom in furtherance of the care? She's actually she was questioning her daughter more than the police were. And it wasn't about her treatment. It was about, you did this and you're going to be in trouble and all of those comments. And in fact, if I remember correctly, I think the police even at one point said, please stop. So how was the mom there in furtherance of her care?
I think we have to step back and look at the totality of the circumstances for that. The statements that you're pointing to, Justice Zamora, or from mom, are her own reactive statements to what she's just learned. But in the course of Alexee's care, she brought her there as her emergency contact. She was asked by medical professionals at one point to help her get into her gown. She's been going back and forth to the bathroom to knock and see if she's okay. She's sitting by her daughter's side. She's advocating her. That's absolutely in furtherance of care. Just because we now in retrospect think, oh, some of her statements might have been against Alexee's interests, That does not mean that in the moment she was not there in furtherance of care and that the physician-patient privilege does not attach.
So we have exceptions to that.
Correct.
Let's talk about those.
Let's talk about D4.
Let's talk about a statute that also exempts it, a statute by the legislature. We have, interestingly enough, this privilege exists in statute, seems a fair rule was generated out of common law, 32A45. And then let's talk about those two things, because it seems to be a high burden on this doctor who has an obligation to report a crime. I think perhaps lawyers have that obligation. You know, take a separate factual scenario in which they ask a 25-year-old, you know, stabbed in the leg, I killed somebody. They having that conversation as a doctor and a patient, I'm not sure it means the exception doesn't apply. Why doesn't the exception apply?
So you're saying, why doesn't the mandatory reporting exception apply to the statements that are happening after the collective enters the room?
Or under the statute shall not be excluded on the grounds that the matters be subject of a physician-patient privilege or of their similar privilege under 32A or 5.
Right. So I think there's a couple of things here, and one of them is that the report was already made to the extent that it was applicable. And I just want to step back for a moment because we've got two operating statutes. The state has focused exclusively on 32A43, but there is also, for your honors, 2411.5, and that's reporting a suspicious death. 32A43, excuse me, is part of the Children's Code, and we know from Strouch and its legislative history that the purpose of that statute is to intervene and protect a child from ongoing abuse. And so hence the mandatory reporters that are reporting abuse. And that statute uses the language that a mandatory reporter, and obviously the doctor is one, if they have reasonable suspicion that a child is an abused or neglected child. And then it goes on to a whole slew of legislative rules that have to happen.
Abused? The baby was murdered. Look at this. He was murdered.
But the defense's own Exhibit D at the suppression hearing, the defense's own Exhibit D, as in Delta, talks about how the Leela, the custodian lady, what caused them to call the police was that she had found a baby wrapped in a trash bag under another trash bag. Now, as sad as that is, clearly that's a suspicious death. No different than if a 30-year-old had been found in the cleaning supply room with gunshots to the head. And so I wanted to make a few other quick points. So in custody, I know there was a lot of talk about what the charge nurse said, and I maybe didn't articulate this really well earlier, but my point was that whatever was told by the charge nurse to the police would not have affected the defendant's objective reasonable view. It's an objective view of what a reasonable person in that situation find themselves to be in custody. And none of what was said to the police in the hallway would have been known to her. It's worth just a few.
But it's not about what was known to her. It's about what was known to the police when they said, yes, sure, we will go into the room and have the conversation with you, because that's their yes to the statement. So it's not about what she knows. It's about what the police know and what their motivation was to go in the room and have a conversation with Ms. Trevizo.
And I understand that, but and certainly if the police had gone there, gone home.
The police were there because police do police work. You see, they detect, they investigate, they send all of their evidence to a DA. Doctors do doctor work. And so when they had a phone call saying, we have a dead baby here, and we have a girl that came in pregnant, and she's not pregnant anymore. No one did a damn thing wrong to her. Who on earth is buying this story? And what is wrong with these damn judges? Have they lost their mind? They're arguing. They're arguing with attorneys. They're arguing with their own state.
With their guns drawn or something, saying you're not going anywhere, and immediately have made it clear you're in custody.
But they don't have to say any of those things for it to be custody.
And I understand that, but certainly what the defendant is perceiving or hearing is really what is the defendant perceiving and reasonably hearing and seeing. The one thing I wanted to point out is this reference to the police being armed. I mean, it's common knowledge to anybody that the police are armed. They could be safe 1 minute and 10 minutes later be dealing with a very dangerous situation. I'm not saying in any way, shape, or form the defendant.
But what about where they were standing in the room? Opposing counsel talked about their location in the room, which was in front of the door. That doesn't seem to support the position that it was not in custody.
Although I would argue that the fact that for nearly about 2.5 minutes, they said absolutely nothing. They just stood there and observed certainly bears on defendant's perception. Just a quick 1 or 2 quotes from Garrison, because Garrison really, the Connecticut case gets to the heart of this. Garrison talks about not all restrictions on a suspect's freedom of action rise to the level of custody. And then they go on to talk about whether a reasonable person would believe that there was a restraint associated with a formal arrest. But another thing that Garrison mentions, I guess this is the part I looked for earlier and I couldn't quite find earlier. Garrison says there's nothing in the record to suggest that a reasonable person in the defendant's situation would have perceived the police officers to be exercising any control or authority over the medical staff. Indeed, the record demonstrates that the officers did not assert control over the medical staff and that the questioning did not delay, interrupt, or restrict the defendant's medical care. I don't want to belabor the point, but if you do get a chance to see in Johnson, the Virginia case from the notice 2 weeks ago, Johnson gives a list of the kind of factors that might be relevant in a hospital, and one of them is whether the police maintained a constant presence in the patient's hospital room. As I noted, from about 3 a.m. to when she leaves in the helicopter at 4:30, you can tell from their camera they're out in the hallway. But one other thing I wanted to
But they've told her.
And I understand.
We're out in the
But she already
hallway.
made the statements.
And they,
Which is equivalent to being in the room to be like, we're standing out right outside the door.
Yes, but again, at the point of the 3 minutes into the lapel video, when they tell her you are detained, you're not free to leave, you're not under arrest.
You're the one who raised they were outside the room. You want to focus on the 3 minutes, but you also want to focus on, oh, they were good guys. They left the room after the 3 minutes. Can't conflate it.
Yeah, and I understand, but my only point is that even if the court wants to consider the point where she's told she's detained to be custody, the motion should have been more specific on that, because I don't think there's anything in the first 3 minutes until she's told she's detained that would lead a reasonable person to believe they were in custody. And I would be remiss without at least mentioning this. If you look at the judge's findings at RP 159, I'm sorry, 158. The judge in her conclusion of law number 3, record proper 158, the judge says, Dr. Vasquez, by failing to advise Trevizo of her right of confidentiality, and she cites Rule 11-504, acted as an agent of law enforcement. I'm not reading the entire paragraph on RP 158, paragraph 3, but the judge seemed to be reasoning that because the doctor did not go in and affirmatively say, before you say anything, you have a physician-patient privilege, that the doctor's failure to advise the defendant of that made her an agent. There's several problems with that. That's not the test that Santiago provides. Santiago, of course, is the case. This court, 2009 NMSC 45 says it's A, whether the government knew of and acquiesced in the conduct, but 2, whether the party performing the search intended to assist law enforcement efforts or to further his own ends. And Santiago makes it crystal clear in paragraph 24. It makes it clear that if it's a mixed motive, that's not enough. So in other words, even if the doctor was thinking, I do want to help the police, but I'm also concerned because I'm the doctor, I'm in charge of the ER, it's 2 o'clock in the morning, they're going to be Artesia General Hospital Board of Directors to answer to. I need to find out what's going on. I also need to find out how it impacts her care, because one thing that's clear from the video is the doctor throughout all this made it clear your care is paramount. Even Sergeant Anaya says the number one priority is your care. We're going to step out if we need to, and the number one priority is your care. There's no evidence in the record that the doctor was motivated solely to help the police.
Wait a minute. This girl goes into the emergency room. She's got these backaches She's asked, are you pregnant? She says no. They then do a pregnancy test. It comes out positive. They don't tell her. They don't tell her that the test shows she's pregnant. After the baby is delivered in the bathroom. So she comes in and says, we found a dead baby in the bathroom. Worse to that effect. It gives weight to the assertion that they thought from the beginning, the doctor thought from the beginning, she lied when she said she wasn't pregnant. And now she's confronting her without the benefit of having given her any medical information that she in fact delivered a dead baby. So that seems to me pretty agency oriented in terms of assisting the police.
Well, again, Santiago says that it has to be solely to help the police. Santiago says that there's any kind of mixed motive, like you have a professional interest.
An inference can be made, it is solely to help the police.
I don't believe that inference can be made under Santiago, but I will say this, Justice, and I think this points to a good point. Even if you give the defendant the benefit of the doubt that she did not know she was pregnant, immediately upon giving birth, the natural thing you would think anybody would do is, help, help, I just had a baby, help, help, I need help. She did not tell anybody for 30 minutes. It was 30 minutes later that the cleaning lady found the baby, and obviously another 5-10 minutes till the police showed up. I think one can make a good argument that she did not even from the beginning avail herself of the physician-patient privilege. State v. Roper, 1996 NMCA 73, paragraph 6, said the privilege is designed to encourage patients to make complete disclosures of symptoms. I would argue that if you're hiding a material fact from the doctor that you just gave birth to a baby, you're not asking for help, arguably you're not even availing yourself for a privilege. Now, I understand after the fact, now that she's caught and she's in trouble, she wants to say, my privilege was violated. But State v. Strouds, 2015 NMSC 9, paragraph 44, states expressly, privileges often have limits, particularly where there are conflicting interests that may outweigh the interest of confidentiality. And it's interesting that Strouds notes in paragraphs 29 to 31 that New Mexico in 1973 became one of the earliest states in the country to impose a mandatory reporting duty on all persons. So New Mexico has a rich history of protecting children and babies. And the other one more thing I wanted to note is it's also interesting that some of this privacy and privilege is a little bit pick and choose what serves me. There was a lot of emphasis in the answer brief about privacy, and they didn't respect her privacy. And yet there's something in the answer brief where they say, well, the hospital let her go to the bathroom unattended. Well, she's 19 years old. It's ludicrous, almost incredible to me that they expected the doctor to go into the bathroom or a nurse to go into the bathroom and stand over her to make sure she didn't do anything. So there's got to be some treatment of, you're 19 years old, you're a responsible adult. I think that's been a little lacking here in terms of the defendant certainly has rights, she's on trial, but there has to be something said for the baby's rights too.
Thomas, anything else? Any other questions? All right, thank you.
Thank you, Your Honor. Thank you for the good questions.
In the matter of S1SC 40478, the court appreciates the briefing and oral argument today. This matter will be taken under advisement and is deemed submitted. Court is in recess. Thank you.
I'll be damned. The court has to stand in recess with all of this. And this isn't even the trial. These are oral arguments because they took their argument about HIPAA and her rights being violated in the hospital room. Then they have to decide if she actually was legally charged. This is infuriating. Infuriating. I can tell you something right now. That baby did not just fall out of her. She knew the day before she was in labor. She knew when she was snuggled up with her boyfriend, and then her mom came to pick her up, and she's just like, I need to go to the hospital. My back hurts really bad. And her mom's saying, it's constipation. It's constipation. Yeah. When you're at the hospital, let's say I'm just going to pick someone out. Let's say V. Oakley stabs Susan. And Susan's at the hospital and doesn't want to talk. Well, the police are still going to talk to Susan, and she's under medical care. And then they're going to start working on their case because they know someone has done something to someone. They knew that Alexee doesn't have the brains or the education to even know the difference between a stillborn or how to deliver a baby. They knew that. They knew that. So they had every right to investigate, especially once they were called under, let's write this down. Let's write this down. Phrase the day. The duty of evidence from the hospital. I don't know what these judges are doing. Well, hello, Cool Gamer. Cool Gamer just became a new YouTube member. I don't know what these judges are doing, even entertaining this argument. They know the argument. They were arguing back. Some seem to be on Alexee's side and some seem to be on the police side. I think it's absolutely crazy. What are these people thinking? We know what she did. You know how we know? Because she admitted it to her mama. And her mama is a crime all in its own. Whew. All right. On this one, I'm a little too heated up. Little too heated up. I thought the Attorney General had a great argument. Now, I hate all that shit. S.4-C. And if you look at Rhode Island versus, oh, piss on that. Let's let you and me. Let's let me and Melanie go in there. We can bitch someone's ears off. Don't need fucking case law. We know the law. The law is simple. You don't kill your child. You don't kill a baby. A baby comes out of you, you don't cover it up. You knock on the damn door and say, I need help. These legal arguments with these, I'm not going to say the word. I'm not going to say the word because I'm going to get in trouble. These legal arguments hold no water. None with me. Watch the bitch get away with it. Just watch. All right, you guys. I will see you back here tomorrow at 9 a.m. And, Brooks has got to take something to get my blood pressure down because I'm pretty PO'd about this. Well, I think you guys are the best. Next to my cat and my kids and DT Driver. But I love every one of you to bits.